Assalamualaikum and salam sejahtera. I'm going to present tutorial 8 delegated legislation on question 3. Question 3. Define subsidiary legislation. Discuss the various methods of controlling subsidiary legislation. In your opinion, are these methods sufficient to prevent abuses of delegation of legislative powers? The answer: subsidiary legislation is created by other lawmakers, typically government ministers or public bodies, using the authority granted by them by acts of parliament. It may be referred as delegated legislation. Subsidiary legislation can be defined under Section 3 of the Interpretations Act 1948 and 1967, Act 388, where it states that subsidiary legislation means any proclamation, rule, regulation, order, notification, bylaw, or other instrument made under any act, enactment, ordinance, or other lawful authority and having legislative effect. This can be seen as an example based on legal profession, practice and ethics, rules 1978. The Bar Council generated this subsidiary legislation through the power granted to it by the Legal Profession Act 1976. Referring to the Section 77 of the Legal Profession Act 1976, it is provided that the Bar Council may, with the approval of the Attorney General, make rules for regulating the professional practice, ethic, conduct, and discipline of advocates and solicitors. Regarding this example, while the Legal Profession Act 1976 is known as the Parent Act, the Legal Profession, Practice and Ethics Rules 1978, which are made by the Bar Council, are known as the subsidiary legislation. A case that can be emphasized the definition of subsidiary legislation is the case of Datuk Muhammad Farid bin Haji Ahmad Ridwan Lawan Pendakwa Rakyat 2009 3 MLJ 378, where Section 3 of the Interpretations Act 1948 and 1967 was referred by the High Court Kuala Lumpur as it defines subsidiary legislation as any proclamation, rule, regulation, order, notification, by law or other instrument made under any act, enactment, ordinance, or other lawful authority and having legislative effect. Upon remaining legislative authority, Parliament and state legislative assemblies can distribute the power available to any individual or entity, usually Yang di-Pertuan Agong, the Minister of the Cabinet, or local authorities, individual or entities that are entrusted with authority. The subsidiary legislation needs to be in line with the Parent Act. It may not be ultra vires the Parent Act. This principle can be found under Section 23, subsection 1 of the Interpretations Act 1948 and 1967, Act 388. Next, there are a variety of methods in controlling subsidiary legislation. There are four ways it can be controlled. Firstly, it is by the process of consultation, then the process of parliamentary control, thirdly, through judicial review, and finally, through publicity. To start off, according to this method, before a subsidiary legislation is created, the responsible party who is going to make the law needs to seek prior consultation with the relevant advisory bodies and interested groups who are involved with the subject matter as first crucial step. This step is a must before the subsidiary legislation is finalized. A compulsory requirement is needed for consultation for some parent acts. If it is not done, the subsidiary legislation can be set ultra vires and becomes void. Secondly, it can be controlled through the process of parliamentary control. There are two ways that the parliament can use this. Firstly, the parliament may take control over subsidiary legislation by repealing the parent legislation or the subsidiary legislation. And secondly, the parliament, through its parent act, requisite that the regulations made under it be presented before the parliament. Here, the regulations will only become effective if there is no negative resolution against it. Some parent act may some parent acts makes this as a requirement, and regarding this, the subsidiary legislation will only become effective when an affirmative resolution is passed by the parliament. Thirdly, it is controlled through judicial review. Due to this method, if a subsidiary legislation provides laws that are inconsistent with the Parent Act or go beyond the authority granted to it by the Parent Act, the court may consider such subsidiary legislation to be ultra vires the Parent Act and thus void. Lastly, it can be controlled through publicity. Subsidiary law must be published in the Gazette under this approach. It will only take effect on the day of publication or such other dates as may be stated. In my opinion, I think that these methods are sufficient to prevent abuses of delegation of legislative powers because it is organized through a systematic process, and it can be used to avoid any useless subsidiary legislations because of the methods that it needs to go through. Thank you.